Howdy ho, chickadees. Happy Monday. It is the beginning of a glorious week. Are y'all adjusting to the time change? I personally was very ready for this time change. I am tired of getting up at 4:30 or 5 o'clock in the morning. And so I was very ready. I feel fantastic. It's still daylight out right now. Woohoo! Life is good. So I hope y'all are adjusting as well as I have been adjusting because I'm feeling pretty spicy today. Like this morning, I woke up and I'm like, I'm pretty sure I heard the devil say, crap, she's up. It was that kind of a day. It was that kind of a day. So I'm happy y'all are hanging out with me today, or tonight, I should say. Let's not forget, couple reminders. Dale Warner, the jury did not deliberate on Friday because one of the jurors was ill. So they took Friday off. There was no deliberation. And they took today off. Also no deliberation today. Tomorrow, the jury will be back and we'll see if we get a verdict tomorrow night. I got to tell y'all, I got some real life stuff happening. So Ms. D's got to get the wig trimmed up again, and that's tomorrow night. So if there is a verdict tomorrow, I will replay the verdict. It is going to be a little later because I got to get the snippety snip done on the old hairs. So keep your eyes peeled. If we get a verdict, I'll send a notification sometime around 5-ish and let you know what time we'll be getting together. If not, I'm going to have to do some finagling for what we'll do on Wednesday for Wine and Crime Wednesday in case we get a jury or get a verdict for that. I am so sorry. I am getting spammed to death right now. There, I've stopped it. So that's what will happen as far as Michigan versus Dale Warner. I was caught up on Corey Richens, of course, until today. And Corey Richens happened. I have not finished today's testimony. I think they are still in court right now, aren't they? I'm not sure. I didn't check it when I came home from work. But I am to the point of Cody Wright just finished being voir dired. So no spoilers, please, in the chat. No spoilers. Kelly, we're supposed to get hail, tornadoes, and such after around 4 p.m. So for sure we'll get a verdict. Oh, and court did wrap for Corey for the day. Okay, good. Good. Alrighty, let me say hello to all of you. We all see that Kelly, our great mod, the one and only, is here. And Kristen, the fantastic Kristen Vasquez, is with us. Jillian, she's shutting the front door and coming on in. Who else? Melissa. Hello, Melissa. Yes, we are going to be talking sports ball today. Well, at least the head coach for the University of Michigan football team. Let me see. Peppermint PJ. Hello, and thanks for coming on back. So happy to have you. Court wrapped. Melissa got her wig trimmed too. Good girl. When I get mine trimmed, I swear my head is about 3 pounds lighter. I got a lot of hair, y'all. And so when I get it, I'm like, whoo, I feel lighter now. So, hello. Oh, good grief. Kristen already added. Rein in the memberships. Thank you so much for the 5 gifted misdemeanor memberships. You are unbelievably kind, and we like that on this channel here. So thank you so much. Now, for all of the individuals that are hanging out here tonight with me, I want to say thank you. If you haven't left your DNA on the thumbs up button, you need to do that. Oh, and look at I got some peepers. I see because of the memberships being received. I got some peepers. Some of you that are from Cat Not Williams know those are lurkers on her channel. Your peepers over here. I see peepers. I see DB. He's a peeper. Happy to have you, DB. And I don't think I recognize anyone else. So, make sure if you haven't subscribed that you do. There will be more content on the horizon, of course. I'm not entirely sure. I may be doing another trial replay in the evenings. Haven't decided what that might be. And hello, Granny Debbie. So we'll do that. If you're on Replay Crew, thank you so much. I appreciate all of your comments. It makes my day when I get comments from my Replay Crew. And with all of that, I think we can get into it. Are you all ready to get into it? I'm ready to get into it. Let's see what happened with Sherrone Moore. So let me kind of give a little bit of a synopsis in case you are unaware of what this is about. Sherrone Moore was the head coach of the University of Michigan football team. Y'all know I'm a Wolverine. I love my Michigan Wolverines. But there were some shenanigans going on the old staff there at University of Michigan football. And one of those shenanigans is that it appears Mr. Sherrone Moore, the head coach, had a relationship with one of his assistants. And you can, it's not a good idea to do that. From a management perspective, you really shouldn't have a relationship with a subordinate. Just saying. And so things went a little sideways. And of course, he got in really, 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 really big trouble. And so he kind of went off the rails. The university found out about it. They fired him. The day he was fired, he went wackadoodles and went to the girlfriend. Well, I think it's the girlfriend's house. He's married. He has children, but he was having this relationship with his assistant. And he went to her house with a knife. I have heard conflicting stories. Some of those stories say it was a butter knife. Others say that he didn't take a knife, but he showed up there. I don't know what the truth is. I think that's why Judge Simpson decided there needed to be an evidentiary hearing. So we're going to watch tonight the initial hearing that took place that caused the judge to decide an evidentiary hearing was necessary. And instead of us getting that evidentiary hearing, Mr. Moore decided to take a plea. So we're going to watch all of that. It's a couple hours long. And we're going to see how it's all unfolded. I have not seen the entirety of the initial hearing. I saw a big part of it, but I've not seen all of it. So a lot of this is going to be a first-time viewing for me, and some of you in the chat and watching, it may not be a first-time viewing for you. That's okay. We're going to go through it, but please no spoilers. You know how I don't like the spoilers. It makes me cry. All righty, let's do it. Let me get the screens as such. All right. Oh gosh, where am I going to put myself? I guess right there is okay for now. All right, let's zippity-doo-dah until Judge Simpson comes in. I did want to see, Mr. Moore come on in the courtroom, though. Zippity doo dah, zippity.
Court does vote case. The people state Michigan versus Sherrone Moore. Counsel, please state your appearances, please.
The sound will get better. I do remember that.
Good afternoon, Your Honor. Ellen Michaels, on behalf of Sherrone Moore, who is present in court. Please state your name for the record.
Sherrone Moore. Thank you. All right, please. And I guess the first order of business, Counsel, this is your motion for a Frank hearing. Now let's go ahead with that. There was, however, a motion that you had filed in the latter part of last week requesting information from the court to accept a reply brief. Did people have a response to that? I will just say this, the information, the legal information contained in there, I already had done the research, so I knew it.
Agreed, and same, and the court can take it for whatever the court thinks its import is. I plan to respond to it formally, if that's acceptable.
That's acceptable.
Thank you.
All right.
He's got that look on his face looking at her like she's an Ohio State player.
Good afternoon. May it please this honorable court. Thank you for accepting my motion in reply to the prosecutor's response on this issue. The importance of the reply that I filed is that it states clearly and unequivocally that the relationship between the parties in a stalking allegation matters. It's not stalking if the communication has a legitimate purpose. As stated in my reply, and as what Your Honor knows, is that under recently published appellate court case in the state of Michigan, it is clear that the relationship between the parties matters.
I want you all to know all of that clickety clicking and everything. It's going to get cleared up and you're going to be able to hear great. I promise.
In that case, there was a stalking charge and there was a trial. At trial, the evidence presented that the alleged victim was a probation agent and that the alleged defendant was a probationer. The probationer contacted his probation agent many times, to the point where the probationer said, please stop contacting me. The probation agent felt harassed. He had her stalking charges filed. At a bench trial, there was a finding of guilty. On appeal, the appellate court stated that the employment relationship is relevant, or excuse me, that the relationship between the probationer and the probation agent is relevant. That it's relevant because what it shows is that contact between the two parties had a legitimate purpose. The contact was for the probationer to notify his probation agent of certain things. What the court said was that when looking at the reasonable person standard of whether somebody feels harassed, you have to look at whether a reasonable person in that position feels harassed, which gets us to what happened in this case. In this case, Detective Welker presented to the magistrate facts to seek an arrest warrant for Sherrone Moore on stalking charges and on home invasion with intent to stalk. In the facts that she presented to the magistrate, she left out the information that Sherrone Moore was the boss of the complainant. The complainant was the executive assistant to Sherrone Moore, who at the time was the head football coach at the University of Michigan.
Oh, we know that part.
Why does that matter? It matters because the communications that were presented to the magistrate were 12 alleged phone calls that were unanswered. The 12 alleged phone calls were on a work day. The complainant in this case had not taken a leave of absence. She had not left her job. It was working hours, and she was the executive assistant of Sherrone Moore. Sherrone Moore was never told not to contact purposes. In fact, he was never told not to contact her at all, but that's not what we're here arguing right now. I'm talking about the legitimate purpose. If there are contexts for legitimate purpose, it is not harassment. As I stated a moment ago, the phone calls went unanswered. So there's no evidence as to what the intent of those phone calls were. I can tell you that there was evidence in the police reports that were tendered to me by the prosecutor's office that a text message was presented to Detective Welker by the complainant's attorney as a way to show contacting her and she is feeling harassed. It was a screenshot of several text messages. In those text messages were several messages.
You're talking about one before December 10th?
There was a screenshot of messages where there was messages from December 9th and December 10th. The days.
Okay, so yeah, I need to talk about this because Kelly's got kind of what I was thinking too. So you can stalk someone you work with because it's during work hours. I don't think so. I'm not going to agree with that. Here's the issue. I thought the whole stalking part of this, and even if she is considered an employee and this is going on, is it not how you are perceiving the behavior? Y'all let me know in the chat, but I personally thought it was about the perception of the person receiving the behavior, so to speak. So it doesn't matter what the intent is, if it is felt by her that he is stalking her and harassing her. I thought that's what mattered. Y'all tell me in the chat, but because y'all know I'm no legal person. I'm just saying I thought that's what it was.
That the alleged stalking occurred.
That were presented, you're saying that there's in the report, because by design, I don't have the police reports, right? So are you saying in the police reports, there are text messages from, what would it be, the 8th and 9th or the 9th and 10th? But prior to the 10th?
Correct. Yes. The police report is where I obtained that screenshot that I presented in my motion. That's how I know Detective Welker had that information, because it was tendered to me in the police report from the prosecutor's office.
How many text messages were in that report?
In that screenshot?
Well, you're saying that in the police report, there were a number of text messages.
There was a screenshot of a conversation. And in that screenshot of the conversation that is on page 5 of my original motion, there are, it starts, can you have Dave write a statement? Okay. What is the latest you can get me out? I called him.
What?
And then that would have been on Monday, December 8th. Tuesday, December 9th is one text message that says, please answer. And then on the day of the incident, it says, can you call me when you get a chance?
Yeah, because I remember this was a Wednesday that everything went sideways. So, and it was the 10th. So that would make December 8th, Monday, Tuesday the 9th, Wednesday the 10th.
So what was laid out in your brief, those were text messages in various days?
Correct.
Okay, go ahead.
Yes. That screenshot was presented to the complainant by Detective Welker. Detective Welker asked her about those messages. And in the conversation, which is documented in the police report, Detective Welker was told by the complainant that the first message and the second message and the third message were work-related. The complainant confirmed that they were work-related. The one where it says, please answer, and call when you get a chance. It's my belief that those text messages were also seen as work-related. Those were not part of.
Well, it's your belief, but did she say that, or?
She said to the detective said, was this work-related? And she said, yes, that's work-related. They showed her the whole screenshot. And she said, are these text messages work-related? And the answer was, yes, those are work-related. And then she was asked, are there any more text messages that you haven't given me? And the answer was no. And that's all in the police report. So the reason, again, to connect the dots is that there's acknowledged communication that was work-related during those days, which goes towards the phone calls. She doesn't know if they're work-related or not. We don't know if they're work-related or not. It's our position they were. It was a work day. There's no evidence to show otherwise. Because the complainant was able to distinguish between communications that were work-related. She identified the texts as work-related.
Let me ask this, because again, I don't have the report. Was information presented to the detective that these phone calls were actually made?
No. There were no phone records at that time. It was verbally said. There were no phone records. It was presented
I
to.
understand that there may not be phone records, but was there a phone log at all?
Yes. I'm not disputing the fact that there were 12 calls made, if that's what you're asking. There were
Right,
calls made.
but here's, I guess, what my point is that it doesn't indicate in the swear theory that it indicates that the complainant is saying these things, but it doesn't say we look and here they are.
Correct.
All right.
Kristen, the only way I can explain it is this way. For whatever reason, he ended it with her. She was upset about it, so she went to the athletic department to report it. Here's what's interesting. What I had seen in all of the reporting led me to believe, oh, Janet, get your act together here. Led me to believe that she broke it off with him and she ended her employment and went to authorities about what was going on because of him. She left the program and he was called to the head department and was fired. Yeah, that I think that I didn't get the part in the story that that he ended the relationship. I thought it was very much the other way around. She ended the relationship. He then, this is what I had originally heard, he then fired her and then she reported it. No. Clear as mud here on Misdemeanors channel tonight. This is why I have to listen to all of this, because I don't know what the heck is going on. And I think Judge Simpson at the end of it was like, I don't know what the heck is going on. I lost his last year's Easter egg, y'all. Let's see if we can figure it out.
Yes.
So I'm just trying to make sure what was, I guess at that time, known.
It was known that these calls, that she received phone calls from Sherrone Moore that were unanswered. That's what was known.
Okay, so again, I'm just trying to clarify my own. Between the 8th and the 10th, there were phone calls.
Correct.
We don't necessarily have call logs, but there were phone calls. That's what you're not disputing. But none of these phone calls were answered.
Correct.
All right, go ahead.
At the time of the swear-to, Detective Welker knew that there was an employee-employment relationship, and that wasn't presented to the magistrate.
Are you saying that that was intentionally done or just done?
I believe it was intentional, but I don't believe that I have to prove that. I think that the fact that it is a relevant and material fact to a stalking charge makes it relevant and makes it a material omission.
Well, I have two questions for that. Do you have any case law where a hearing of this type, which we'll call a Frank's hearing, but may or may not be, but, was an evidentiary hearing was then conducted based upon omissions as opposed to false or intentionally reckless statements?
I, in fact, have a case where that was the case. In Oakland County, People versus Galloway, we had a 3-day evidentiary hearing based on the omission of relevant information that a tip came from a privileged source. And Judge McMillan in the Oakland County Circuit Court granted my motion for a Frank's hearing, ultimately suppressed evidence that was appealed to the Michigan Appellate Court, and that was upheld. There's quite a bit of case law where omissions are considered Frank's violations.
Okay, go ahead. Well, just one other question before you go. In paragraph 10 of your original motion, you stated that there were, I guess, fraudulent statements that were made. And I'm trying to figure out what those may have been. Did you want a copy? I have.
I have a copy. Oh, I have it right on top. I'm sorry, in paragraph 10.
Paragraph 10, you state that Detective
Yes.
Walker knowingly and intentionally and or with reckless disregard presented false testimony.
Yes,
And I guess when I read these swear to, I was trying to figure out, I was looking at your brief, what are you claiming that's false that she presented?
I thank you. That's a great question.
I know I asked.
Yeah.
Go ahead.
We love you, Judge Simpson.
The information that Detective Welker presented at the swear to, a large portion of it came from information she received from Heidi Sharp, the civil attorney who was representing the complainant in going to General Counsel at University of Michigan to disclose this relationship that is the basis of this event, part of how we got here. This
Hell hath no fury like a woman scorned. And until men figure this out, if that's where all of this originated, I do not remember seeing it that way in the news. But hey, who's to say they ever get it right in the news? You know what I mean? So he fired her. Is that, or I'm sorry, he broke it off with her. She then quit and reported him. Is that where we are? I have questions because I know there are 911 calls in which his wife was panicked that he was going to hurt himself. Like I need more.
Heidi Sharp is when Mr. Moore came to the complainant's apartment, the first person that the complainant called was Heidi Sharp. Heidi Sharp then calls 911 and says a series of statements that are in my motion that she did not have personal information of and had no basis for and are untrue.
Okay, that may all be well and good. I understand that portion of your argument. But in paragraph 10, you're saying that the detective intentionally gave false testimony, submitted false testimony.
Right, I'm getting there, so.
If I'm the detective and I remember what somebody told me to the court, I don't know that that's false.
I understand. So what happened was after this attorney who was not present gave this information, the actual complainant was interviewed on 3 separate occasions at her residence, which was all on the body-worn camera that I reviewed. The body-worn camera statements made by the complainant were a part of the police report.
Don't we all
Then
wish
there
we
was
could
a
watch
follow-up
those?
phone call with Detective Welker to the complainant. The information the complainant gave to Detective Welker conflicted with the information that Heidi Sharp gave the detective. So
But that doesn't mean that Detective Welker presented false testimony. It just means that, which seems to me to be at the core of your argument, that there was information that was omitted.
well, if Heidi Sharp, who is not a witness, said something that the actual witness contradicts, then it is false. Or unless you're saying that the person who wasn't present is more reliable than the person who was present. It was contradictory.
Well, I get kind of what you're saying, but you're,
Okay, I'll take it a step further.
okay.
Heidi Sharp stated that Mr. Moore had a long history of domestic violence against Shiver. Okay. Shiver herself never made those statements. She never gave that information. There is no record of any of that. There is no documentation of any of that. There is no criminal history. There's nothing to support that statement made by Heidi Sharp. Through 3 interviews, the complainant never says any of that and also doesn't support it. She was asked by Detective Welker about assaultive behavior, and she said, no, there isn't any. Heidi Sharp's comments were completely contradicted, and Detective Welker, by submitting to the magistrate Sharp's statements instead of the complainant's statements, was reckless and intentional and false. And the purpose of a Frank's hearing
I
is,
don't know, see, I'm still having an issue with the false part. I get your argument regarding what may have been reckless or an omission in either reckless inclusion or reckless omission. I get that part. I don't know that, could it be what you're really trying to point out to the court is that by placing that information in, the context of the relationship was placed in a false light,
that is
as opposed to what she said being false. Because what she says, what Detective Welker says is, yes, this is what Ms. Sharp said, right? But that's what happened, sure.
That is a way to look at it, but I do believe it goes a step further, that a detective is an officer of the court. It is their job to investigate. It is their job to present truthful information to a magistrate, to show.
Ma'am, have you met a man by the name of Michael Proctor? Because I think you might have a slightly different opinion and you wouldn't make that statement so strongly if you happen to know Mr. Michael Proctor or maybe a Lieutenant Tully. I don't know if you've ever known about them, but the statement you just made would not bear fruit with the two of them.
Just the picture in order to get for the magistrate to make a determination. The magistrate needs information to make a determination of probable cause of whether to issue an arrest warrant. That's a big deal. That's a due process at its core. And
I agree.
in this case, where the detective talked to Heidi Sharp and the complainant numerous times, had a picture of the whole situation, had an ability to ask the complainant if it was true or not, had an ability to ferret out what was really going on here, and then present it to the magistrate in a fair and honest way to paint an entire picture. That's her duty under the law. And in this case, the picture that she painted was inaccurate, not supported by the facts of the person who was present, not to mention the omission of the employment relationship.
I mean, we can move on from here, and we might be saying the same thing in a different way. It really isn't that it's false. It's that she may have portrayed an inaccurate context to everything that's going on by omitting certain. I don't know that that makes what she said about what Heidi Sharp said false. It's just you haven't given me everything to give context to what she's saying, whether to ignore it or not.
I guess maybe the better language would be reckless disregard, which is also part of the analysis. So I think reckless disregard is more accurate.
Okay. I asked the question because saying that somebody submitted deliberately false information
That's big.
may be a little bit different from somebody that is sort of reckless in what they present. Let's go ahead.
Thank you. So to get back to what we're asking for, we're simply asking for the opportunity to create a record, to put witnesses on, to create an evidentiary record, to show what they knew and when they knew it, and how it was versus what was presented. We believe that we presented enough of an offer of proof as to what was given to me in the police reports. That's the information I want to go on the record. I am not presenting anything that the prosecution doesn't already know. But I believe that in the interest of justice, a record should be made to establish the information that was given to the magistrate with reckless disregard for the truth and the omission of the employee-employer relationship, as well as the omission of the acknowledgement by the complainant that she recognized that communications between her and Sherrone Moore were for business.
Hey, Jillian, you watch us with Nick Starro, but like seeing the reactions of the ladies here. Well, you know, I like Mr. Nick Starro. Y'all know that. I've been on with him a couple of times. Delightful man. And I really, really, really am going to try to get Mr. Nick Rakita on with us to discuss several things. Y'all can let me know in the chat if that's a good idea or not. I have a lot of questions. So.
And knew the difference. And acknowledged that during these days in question, there was communications that were legitimate. And if the communications were legitimate, it is not harassment. And if it's not harassment, it's not stalking. May I have one moment?
Good. I just want one other question on the last point that you brought up. The relationship itself, one could have different relationships. I mean, so a phone call may be for business purposes or might not, right?
Correct.
Or there could be a communication that has a mixed purpose. Correct? I mean,
Correct.
because there are different relationships going on.
Correct.
And in viewing it, as to whether or not a stalking and harassment occurs, the court would have to take into account that those two things can exist at once, right?
Correct?
Okay.
So in doing that, when there's things that we don't know, we often look at circumstantial evidence. So what's the circumstantial evidence here? The circumstantial evidence here is that it was a work day, it was work hours, the employee-employer relationship was intact. There were text messages that were work-related in those time frames that these calls allegedly occurred. And it was, in terms of the dates involved, that was the week that Michigan had found out who their bowl opponent was, and there was all hands on deck.
You know what bowl it was?
Yeah, it was the Citrus Bowl in Texas.
You had to turn it off. No, I don't need to know.
I knew-
I was just asking.
I knew who the opponent was. I couldn't remember Citrus. It was a Citrus Bowl against Texas.
Bowl against Texas.
That Sunday night, they received their opponent. It was all hands on deck. So I believe those facts are relevant. If this were August and it was a break from the program, yeah, there could be a question. But the circumstantial facts of the timing of these calls, and remember, or not remember, but I will state that at the time these calls were made, Mr. Moore had not been told not to call her, and had no idea that she had even gone and talked to general counsel. He didn't know any of that. He was operating in his job.
But wasn't there a call from, or her indication not to call? Or, well, the statement's a little bit different.
The statement is, she said that she didn't want to talk about it anymore, or she didn't want to talk to him anymore, something like that. Not don't call me, not I'm never going to talk to you again. It was more vague and did not address the employee-employer relationship either. It didn't say, I don't want to talk to you and I'm giving notice. I don't want to talk to you and I'm asking for a transfer. I'm taking 3 days off of work, don't contact me. That would all be context to show that they were personal calls. None of that occurred.
I think it's important to point out what
Tell us, Judge Stimson, tell us. Spill it.
according to the swear to, at 6 a.m. on December 8th, she told him that she had nothing more to say to him.
Correct.
Oh. Oh.
Which is different from, I'm taking a leave of absence, don't call me, I'm taking days off.
Hold it.
Nothing about that indicates he should not call her for employment purposes.
I don't know. If you were communicating as far as employment purposes and you're not getting any response, I'm thinking you might make a phone call to your human resources department. I don't know. Maybe if you're like, hey, I've got an employee that's refusing to communicate with me. What up, Doe? Just saying.
The point being is that in order for the court to properly evaluate probable cause, the employment relationship is relevant. We can't even evaluate, or we're having a whole conversation about whether or not the call was for employment purposes. The magistrate wasn't even told of the employee-employer relationship. So this conversation in itself is showing that that was an important piece of information for the magistrate to have known, therefore it's a relevant omission. And just one more piece, just going, actually, thank you.
No, you're good.
Thank you.
Mr. Sherrone.
Okay, so here's one of the problems I have with what she was saying there. The issue that I have is, I think I heard someplace in what she was saying that there were 12 phone calls or something. Y'all, I work in management. I have had employees that have not shown up to work in my management career, and I call them once, maybe twice, possibly twice, to be like, hey, everything okay? You okay? I don't know that 12 times is acceptable for me. That seems excessive. I mean, maybe not. Maybe I am the one that it has not been managing properly, which would absolutely not be out of the question. But I had one employee that I ended up contacting an emergency contact because I was concerned about them. I have PTSD because when I was a very young spring chicken, yes, that time actually existed once, I was working someplace in which our vice president, it was actually Valentine's Day, and there was a very bad ice storm, and our VP didn't show up and didn't show up and didn't show up. And lo and behold, later that afternoon, his wife called us to tell us that he had been in a fatal car accident on the expressway. And so I do have a little PTSD about that. I was about 21, I want to say, when that happened. So if people are late, especially my staff, and I don't hear from them, I panic a little bit. They all know, because I as I bring people on board, I'm like, hey, by the way, if you're going to be late, can you just let me know? Because my immediate thought is that you're dead in a ditch. So could we, get my fears in order? So, but even with that, I'm not going to call 12 times. Yes, he was a delightful man. He really was a delightful man. And he had young children. It was awful. It was an ice storm, lots of black ice in Michigan. He crossed the median and hit another vehicle head on. The other driver was fine, but he unfortunately lost his life. So, yeah, I don't like that. Like, you got to tell me if you're going to be late so that I don't go into panic mode. But still, I wouldn't call 12 times. And that's with the PTSD that I have. Oh, wrong way here, Janet. All right.
Thank you, Judge. Does the court have a place at which you would prefer for me to begin, or any specific questions?
You can start where you'd like. I guess maybe we should start where the defendant started, and that is the relevance of the work relationship.
I honestly would end there, but if you would like for me to start.
Well,
it's
your argument, so I'll let you go wherever you'd like.
Thank you, Judge. Is it all right if I pace, I think, better when I'm on?
That's fine. I should just say.
I wasn't offended either.
Where I start
Thank you,
is
not
actually not in my pleadings, and I beg the court's indulgence for a moment, because there was a legal, factual issue pertaining to this ask that I struggled with at first. At first it was, hey, does Franks apply to arrest warrants? I only know Franks to apply to search warrants. Can I wrap my brain around this?
This lady totally gives me Miss Frizzle. I don't know why, but when I look at her, I'm like, oh, it's Miss Frizzle. Oh, it's Miss Frizzle. Yeah, holy hair lady. Indeed. Indeed. And I have to tell you all, in my house, because I love this phrase so much, I beg the court's indulgence. I now say I beg the spouse's indulgence. Love that phrase.
I believe Franks applies to warrants. I've gotten myself there. Arrest, search warrants. I think there's substantial body of case law for you to to infer that it can apply to arrest warrants. I think what I struggled with most after that is that defendant's ask has always been that you quash this arrest warrant and that you must therefore at that point dismiss this case. And I see no legal authority for that ask. I have found no legal authority for that ask. I have instead found 2 Michigan cases that I think address the issue, maybe not head on, somewhat head on. People v. Burrell and People v. Smith. Happy to give the court citations if that is of assistance. People v. Burrell is 391 Mich 124. It appears to be a 1974 case. People v. Smith is 106 Mishap 203. It's a 1981 case. They draw.
203.
Say it again. 203. Yes, Your Honor. Thank you. Those cases draw a distinction between this court's jurisdiction and a case existing and your ability to proceed with that case versus the quashing of an arrest warrant. Typically, we think of remedies when a court quashes a warrant is that there is suppression of evidence that flows therefrom, right? That's what Frank's is about, search warrant. They were arguing you should suppress the evidence that came from getting this search warrant. What I feel they should be asking, what I can find legal authority for, is if there had been any evidence that flowed from the issuance of this arrest warrant, that they could and should be asking for you to suppress that. But this is sort of a backwards kind of a presentation. That might exist in a situation where there was not a warrantless arrest, where they had perhaps conducted an investigation, written reports, submitted them to my office, asked for charges, gotten an arrest warrant, went and arrested, and then perhaps did a search and incident to arrest, then perhaps got some statements from defendant. That would be evidence that would flow from the issuance of an arrest warrant. Should you, which I don't think you should you grant a Frank's hearing here, and should you further, which I don't think you should, quash this arrest warrant, you're still left with a validly filed complaint. And while, again, I can't find exact case law to spit this exact holding out for us, what I will cite to the court is things like the statutes and the court rules that pertain themselves to, let's say, preliminary examination. And they don't talk about holding a preliminary examination and then at the conclusion of which, if the court finds probable cause to bind the defendant over, that you bind him over on the charges in the arrest warrant, you bind him over on the charges in the complaint. Because the complaint is how we start a lawsuit. Civil, criminal, that's what that is. That's the plea.
I don't know what that business was that she just did with her body, but we got to see that again. Because I am vastly and greatly entertained at this moment. Oh, I got her like mid moment or movement there to spit it out. All right, y'all ready? We're going to see it again.
In the arrest warrant, you bind him over on the charges in the complaint. Because the complaint is how we start a lawsuit. Civil, criminal, that's what that is. That's the plea. That exists. So my position is, what I didn't plead, is that even if you granted everything they asked for, you can't get to, they have not shown you authority for dismissing this case.
Well, maybe not dismissing, maybe, but what if there were not, the court were to go through an evidentiary hearing, get to the end and say, well, if the information that defendant wishes and should have been included before the magistrate, that if that information is there, there would not be probable cause for stalking, then the stalking charge, the complaint would still exist, but the stalking charge would fail. And by necessity, so would the felony, because the predicate offense is the stalking.
And then you would have held the hearing on the complaint, you would have evidence and information on that complaint and get to exercise what we count on you for, which is your decision-making to find or not find probable cause on the charges as they are laid out in the complaint.
I like her jacket. I have jacket envy.
Judge, as to whether or not defendant is entitled to a Franks hearing, of course, my pleading and my position is that he is not. Franks talks about there needing to be a substantial preliminary showing before you make a decision to grant a Franks hearing. Honestly, in Michigan, I think we go better than that. I'll do defendant a solid and say that I don't think that he actually has to show you substantial preliminary showing for you to make that decision. I think People v. Franklin, the 2017 Michigan Supreme Court case, stands for the proposition that this is your courtroom, your motion, your discretion. You get to do that if you see fit. My position is that to do that here would be an abuse of that discretion. I will note for the record that People v. Franklin, that judge clearly had his or her own opinion about the credibility of the CI that was in question, having been referenced in that search warrant. And so in that judge's discretion, based on that concern for credibility that doesn't seem to be laid out very clearly in the record or in the written case law, that judge made that decision and it was upheld on appeal. So Judge, this is your discretion, but again, I submit that it would be an abuse of your discretion.
Would it
Because
really be an abuse of discretion if I were concerned about the context of the relationship that was placed before the magistrate? Because I'm not entirely clear why Ms. Sharp's statements are even part of the swear-to. But her statement being part of the swear-to creates a certain context of the relationship between Mr. Moore and the complainant in this case, right? So I'm not sure why that's there. The court, from the time I received Ms. Michael's motion, and then your response has had and looked at the swear-to, has itself, before necessarily really closely looking at anything, had a concern about what was put before the magistrate. And mainly because having done swear-tos regarding stalking cases, having presided over a number of stalking cases, one of the, I think, primary things that always comes out is the relationship of the parties and the extent of that relationship. So that the court can take into account why communication may be occurring. I mean, some of the, and you know, let's say some of the egregious ones, there's no connection whatsoever between the parties, but all of a sudden it's happening, and then that creates one scenario. Then you've got other scenarios where you have an estranged husband and wife with children who are contacted, and then a court has to go through an analysis about what the context were. So would the court really, would I be in error to have concerns in reading the swear-to that none of that was placed on the record regarding the employment relationship, let alone, might I say, and I'm not even at this point clear as to what the duties are of an executive assistant to a head coach.
Neither.
I'm equally devoid of that knowledge.
But wouldn't that information, right, but wouldn't that information be important for the court to know?
So
Do they know there are a lot of people that work and don't even know what their the activities and responsibilities are for their job? I'm just saying.
Judge, I wonder if I can spit back to you what you have said to make sure that I understand, because I appreciate the court's candor. And And you told me to start there, and I went ahead and started where I wanted to.
Yes.
So here we are, right? There is no question that most relationships have a context. And the court is correct. There is some stalking that exists in the world that is stranger to stranger, and it is what it is. I have encountered precious few of those. Most relationships have context. I think the court was very much in tune with the reality of this situation when the court earlier was questioning defense counsel and had some commentary along the lines of, but can't both things be true? Meaning, can't there be stalking and an employer-employee relationship? And the answer to that is, but of course there can. Simply because there might be some amount of communication between two people that is to be expected or a part of a job. But if it is used and abused to threaten and harass and perpetuate more and additional contact, conversation, varieties of contact, it should not negate stalking. What I will say is that I take issue with defendant's characterization of, I think, EICHLER, the September 2025 case that they have cited to you about stalking. I think really what it stands for, my read of it, is it's a commentary, it's a ruling and a holding on the status of the victim in that case. In that they said, because we all know stalking is a subjective and an objective standard to it, right? It has to have made a specific victim feel terrorized, threatened, harassed, molested, that list of statutory factors, the actual victim, and a reasonable person also must have felt that way. And so what this case
That's what I was talking about
comments on
earlier.
and holds is that it's a reasonable person similarly situated to the specific victim in this case. In other words, would a reasonable probation officer have experienced this kind of communication to be threatening, harassing, molesting, so on and so forth? And the court went on to comment even further about sort of what it means to be a probation officer. And that you deal with individuals on the regular who have difficulty following direction. Court went on to underscore that this communication from this particular defendant did not involve any kind of threats, did not involve going to the victim's home or place of employment. It was simply texts, and they were all able to be characterized as about probation issues. So it is, while it does exist as a case in the context of an employment, if you want to call it that, relationship, it's very specific, in my opinion, to the specific roles that those two individuals played with one another.
Yeah, but that burden rests with the people to show that. Isn't that true? I mean, during the course of the swear to, that would have to be shown to the court. I don't make a presumption that it's one way or another. Do I?
It would be our burden to show what it was.
Well, at the swear to, it would be the people's burden. Seeking the complaint to show that somehow those, you gotta give me something that says it's something other than what might be work related.
So I guess what I would then point the court to is that this complaint warrant alleges an incident on a date. I'm not saying that when we come to prelim here, should we get to that stage and this court orders a preliminary examination, I'm not saying that I wouldn't say to you, Judge, I'm looking to expand that date range. But right now, it is alleged December 10th, 2025. And as we all now know, since we're going to what we know, defendant was fired. And what we know According to the complainant, as is testified to in the swear to, he called her 2 times after that. She didn't answer, showed up at her apartment, barged his way in, grabbed the implements that he did. She felt
What implements?
utterly terrorized in that moment, threatened to kill himself, pointed the implements at her, backed her further into her apartment, eventually left when she got her lawyer on speakerphone, and even after he left, then called her, as is witnessed on body cam, called her yet again, and sent her 2 more texts. I hate you, and my blood is on your hands.
What?
On December 10th, and as was sworn to by Detective Welker, there is more than sufficient probable cause for the issuance of a warrant that includes stalking. That's my position. I have case law because I have had individuals question me as to whether or not behavior that occurs all on one day can satisfy the elements of stalking, that course of conduct, non-continuous, separate acts.
Y'all, there is no world that he is fired from his position and that he has a right to call what he believes is an employee of the University of Michigan. This does not bode well for the defendant. I was kind of on board with, okay, yeah, sure, I get it. Yep, other messages. Oh, all right. My blood is on your hands. I hate you. I'm sorry. That is not how an employee and their subordinate communicate with each other. Wow. Yeah, I don't think I saw up to this or saw past this point or up to this point. I saw before that and that was really it.
And while it is an unpublished case, Judge, I find a lot of takeaway from this case. It's People v. Smothers. So it's 2025 Westlaw WL 348.
And let me just say, I completely missed this attorney's name. I wish I knew her name. She's Miss Frizzle to us, but I am 2 things about her. I am loving the booming theater voice. She is a woman after my own heart, as I too do not need much of a microphone. And I'm liking her delivery. She does not make me nuts or crazy like Miss Shardy Pants.
3111. So it's a Mishap case. It was decided December 3rd of 2025. And it talks about 3 phone calls. 3 phone calls that took place in barely over 1 hour can constitute sufficient evidence for aggravated stalking.
Were those phone calls answered?
Those phone calls were answered, but none of them, interestingly enough, were answered by the victim. They were phone calls that were made to 911 and either a city manager or a city attorney and the prosecutor's office. And they made threats against a specific deputy and specifically threats to kill. That deputy did not answer those phone calls. They were not made directly to that deputy, but they were communicated to that deputy. And that all was found to be sufficient evidence to sustain a conviction for aggravated stalking. So, Judge, I think
So Kristen, I get what you're saying, the relationship part not work, but the defense made a really, really, really big point of saying this was a work relationship. This was all work. All of these communications were in the course of work. So that's how I got on the whole work bandwagon. I wouldn't have been there. I would have been on the relationship part, except for the fact that the defense said it's work. It's work. It's work. So now they've put that light on everything. I'm in. All right, it's work. If you've been fired, you don't get to do that. That's not cool. So yeah, this is a mess.
think on the record of swear to, as it stands right now, when there was no longer any employment relationship because he'd been fired,
That's what I
there were
said.
multiple non-continuous, separate contacts that constitute stalking.
See, I'm not an attorney, but every once in a while I hit a good one and I say something smart. And that was one of them.
I mean, I have another case that has barely even 2 contacts that was sufficient for an aggravated stalking conviction, but I've given to the court if the court.
I guess.
Educate me, Judge
the
Simpson.
Point of those, that the information by the caller was communicated to the alleged complainant.
That certainly had to have happened for that to complete that, yes.
Okay.
I don't know what the electric
But
plant.
that's not what happened in this case.
No, you're absolutely right. There were the 2 on, if we're limiting our focus to December 10th, there were 2 unanswered calls by the defendant to the victim before he then came over and barged into her apartment and did the acts that he did, and then left her apartment and then called her again and then texted her 2 times. Judge, I would like to address the court's seeming discomfort with a failure to place on the record at swear to that there was an employment relationship.
Oh, Kelly. Hello, by the way. And don't you be dogging on my Miss Frizzle. Miss Frizzle has a fantastic looking jacket. I love her jacket. But she looks a little more like Miss Frazzle instead of Miss Frizzle with that hair. But she does look like Miss Frizzle to me.
Perhaps what has been portrayed to the court as a disconnect between what Ms. Sharp, the attorney, communicated to the detective and what the victim communicated to the detective. Ms. Sharp, it appears the defendant takes issue with 3 sort of statements or comments that Ms. Sharp made specifically. One is that defendant had been stalking the victim for months. The other is that he has a long history of domestic violence against this victim. And the third is that he is a very dangerous man.
I think that's supposed to be man, not woman.
What I will first say, because counsel calls all of those false lies, and cites to the fact that there is no criminal history, there are no other police reports, things along those lines. Also cites to a follow-up conversation with Ms. Sharp, where she says, none of the acts that I'm talking about will likely rise to the level of physical abuse in your criminal world.
Y'all are
But
killing me in the chat.
I'm sure you would agree with me that there are many different definitions of domestic violence, and also simply because something has not been reported to the police or there is no criminal conviction for it, doesn't mean it doesn't exist and hasn't happened. Specifically as it pertains to a definition of domestic violence, I always think of MCL 768.27B, so that other act statute, like when we go to trial on a crime that involves an act of domestic violence and we are allowed to introduce other acts of domestic violence, the description. Ms. Shiver did not, on the day that she was spoken to, December 10th, get into the history of her relationship with the defendant.
Oh.
One person did and one person did not.
Oh, spill the tea. We want tea.
There has been a lengthy additional interview and additional information, but we're not here about that. At that time, that was not something, for whatever reason or number of reasons, she was ready, willing, and able to talk about. She talked about December 10th and the fact that they had had an intimate relationship for a period of time leading up to that. So, Judge, to characterize Ms. Sharp's statements as lies simply because there isn't any adjudicated history of it, that misses the mark. There is no mandate that there be an adjudicated history of it for it to be an accurate statement, or at least an accurate statement in her mind. She goes on to talk about, a specific example she gives of what she means by that is that he has a history of threatening self-harm as a way to exert control over the victim, and that he has a propensity to use knives when he does that.
Oh.
So, Judge, we all know domestic violence includes a lot of things, and that emotional harm, again, I point the court to 768.27b in terms of definition of domestic violence, and certainly it could be causing harm or attempting to cause harm, but it can be placing a family or a household member in fear of physical or mental harm. It can be engaging in activity towards a family or household member that would cause a reasonable individual to feel, and then it lists off all of the stalking variables: terrorized, threatened, harassed, intimidated. Those are all under the umbrella, just in that one subsection of law, of what it means, what domestic violence can be.
Miss Grizzle, mention it
there
all.
There isn't any showing that what Ms. Sharp said was false or a lie or inaccurate.
Well, but I think something might be, and this might just come from short knowledge. She stated to the officer, or to dispatch, somewhere, that he had been harassing her for months.
Yes.
I remember that.
If I just take months, meaning 2, could mean more. And I take it from December 10th. That means that he was harassing her as the executive assistant through the majority of the Big Ten season.
Yeah.
I'm not sure, and that's part of the court cut. I don't know how that works, how that would even happen.
Sir.
Because I think,
Judge Simpson, I love you and everything, but just because people are able to work together does not mean that one of them is not being harassed. Trust me when I say this as someone who has been harassed at work. You do your job.
that presupposes that the harassment she was talking about is just phone calls or texts that were maybe work-related, or that were work-related.
So it was there then placed to be a contact. It wasn't just something that the court should ignore.
The employment,
No, that Ms. Sharp's comment.
If she said
I mean,
it on,
somehow,
if she said it on the 911 call, why are we here? I got the impression that like nothing about that had ever been said. If he was harassing her for months, I do remember now hearing that on the 911 call that she stated that. So I'm trying to get behind this whole defense argument, but I have questions.
that creates, or it should have created, I guess, a context to the relationship that's going to form the basis of this document, yes, right?
what Ms. Sharp is saying about it going on for months, that somehow will play into what happens here in this
On
case.
December 10th? Yeah, on December 10th. I mean,
Yes.
Speech to
why
me,
wasn't
Judge.
it all given to the man?
which is meaning that they had an employer-employee relationship.
Yeah, but it's even, and again, I don't know, but I'm just going to assume that it's different than just an employment-employer relationship. I mean, from the standpoint that it's almost like a CEO and the executive assistant to a CEO. I mean, the closeness of that relationship, I just don't know how the court was anymore.
If I had to guess, and that's part of what's challenging here, because we have one record, which is a transcript, and we're all sort of arguing from things we think we know from police reports and investigations. But if I had to guess, I would guess that it's because the detective assumed that as a fact, as a known fact, if I had to guess.
All right. I'm off in the weeds here. I'm going to need somebody to jerk me back on the path because, and it could just be my uneducated stupidity, and that's perfectly fine. I can accept that. But my question is, does it really matter? And if it does matter, y'all will straighten me out in the chat, please. Does it matter that they were employer-employee? Is stalking different when you're an employee than when there is no employee-employer relationship? I'm really super confused by what we are talking about here. And I don't even feel exceptionally tired this evening, so I can't even blame it on that. I'm like all full of piss and vinegar today. So I'm confused. I don't know why it matters whether, because Judge Simpson keeps saying, well, you know, there should have been context provided. Okay, what does that matter? The behavior's behavior, regardless of what the relationship is. You've lost the thread, Peppermint PJ. You're trying to unravel that thing and lost the thread. I think you might be right. Behavior is behavior. I don't know that the relationship an employee-employer. Now, if the relationship was that they were husband and wife, okay, well, that relationship matters when you're talking. Well, honestly, when it comes to stalking, you're probably not even talking about that. We've watched Dale Warner. That man stalked the crap out of Dee. So even in that case, stalking, I'm lost.
That's about as honest as I can be.
No, I understand what you're saying.
Yeah, it's one of those that seems like a judicial notice sort of a thing. By that time on that, that's my best guess.
It may have been a judicial. I don't know if it would be. All due respect to head coaches around the world, I didn't know they had executives. But whatever.
Oh.
I didn't know. But
Judge Simpson, he had an executive assistant that was paid twice as much as anybody else in the freaking United States because he made sure she did. $100,000 a year? It's a $50,000 a year job. That's what the salary was supposed to be. I don't know if y'all knew that, but at least that's what I read. Maybe the media is wrong, but that was what my understanding was.
Certainly the court, the record was not informed of that,
That would be
nor informed what that means. Even as I sit here right now, and I don't know that anybody necessarily can explain to me what it is, I don't know what that relationship is. like I said, I'm taking it from the standpoint that it's like a CEO and the executive assistant to a CEO. And that is typically a very close relationship. There's a lot of communication that happens. And as I was thinking about this case, the only thing that I could sort of in my head equate it to is myself and my judicial coordinator. And that the communication that flows there is different than I have with any other employee in this court. It just is. By nature, if I'm correct in that, I may or may not be, I think it's something that the court would have had to have been informed of. Because at some point,
You see what I was saying earlier? This is, I'm supposed to look at this as an employer-employee relationship. He keeps talking about it.
even for a probable cause standard, the court's being asked, as I said before, to say that, and maybe the court would have had more questions as to what the nature of this harassment was for these months to create a context of this. Because like I said, I can look at it one way and say, okay, 6-7 games into the Big Ten season, I can do that by just looking on my phone if I go 2 months back. And I can say, well, how does, if I'm right about the relationship, the employment relationship, I don't know how that happens. And then I might, if I know that, ask questions about that, right? To put a proper context on these communications.
I can tell you right now, if my boss gets fired, I truly hope the first thing that they do not decide to do is to show up on my front doorstep. What are we doing? What is happening? I'm trying to follow. I'm trying to follow Judge Simpson. I like you, Judge Simpson. I think you are phenomenal. But you are hooked on this employer-employee relationship thing. And there is no world that I live in that an employer-employee relationship, it is okay for one of them to be fired and the individual that gets fired goes on a little field trip to the other's house and threaten them. What are we doing? Oh.
So, I'm sorry, you may go ahead.
No need to be sorry.
Poor Miss Frezzo's like, what do I do with that?
My position is that the detective testified to information that was given to her. Was there an omission of employer-employee, that fact? That would appear to be accurate. Again, my best guess is that she assumed that was a known fact. She testified to information that was given to her. The charge pertains itself currently, as we stand, to behavior on December 10th.
Can I just say though?
Sure.
I get what you're saying, but I'm looking at page 6
Of the square tube,
of
Judge?
the square tube.
Yep.
And starting at line 3, basically.
Please make it make sense.
She stated that after telling him this, that being that there was no more statement, that he continued to call her approximately 12 times and sent her text messages over the next 2 days leading up to the date of the incident. Now, let's just stop there. If I have, it's and I think everybody's right in terms of there needs to be a picture painted for the man. If Miss Sharp is indicating that there's all of this other stuff that's going on, and so if I'm the magistrate, that's what I'm hearing. Then I'm hearing this, that this individual says that she has no more to say to him. And then there are these dozens of calls and text messages that occur over the next 2 days prior to this incident. Frankly, you'd be leading me to believe the negative. Because you're not giving me anything else.
Not sure I follow, Judge, leading you to the
Meaning
negative.
that these communications couldn't have been for any other purpose. I mean, because it's equally as plausible that, I guess, that they could be for the purposes of harassment as for the purposes of work relationships. But by placing it on the record this way before the magistrate, you've given the magistrate no alternative but to believe that it is a continuation of the behavior that Ms. Sharp describes, which I don't know if substantiated or not. That's my problem.
I think the best I can offer the court along those lines, with the exception of not having sworn to the fact that they were employed together and knew about, that Detective Welker passed along the information that was given to her, swore to and testified to the information that was given to her.
Well, I got a problem with that.
Yeah.
Because part of the problem is my understanding, and maybe I'm wrong, but from listening to Ms. Michael's argument, I think I was right. She has the other text messages from those 2 days, right? Somewhere she saw those. But doesn't say anything about them. Doesn't say anything about what those are. Yeah, the one that occurs after on December 10th. Well,
Oh, Kelly, we're lost too. I feel like I need to be with Melanie Little because I am in the land of the lost right now. I don't know what we are talking about because when do you stop? So he's saying they needed to go back 2 days with the text messages, but then maybe what if you needed to go back a week then with the text messages? And then maybe a week isn't enough. Then do you go back a month with the text messages? I'm confused, and it's probably my ignorance about the legal system and what is happening here, but he has completely lost me on this. I don't understand. Everything blew up on that Wednesday. That would be to me what they would present. But the defense is wanting Monday and Tuesday along with Wednesdays. And okay, I need somebody to explain it to me. I'm going to keep watching.
one particularly,
Yeah.
she lays out in great detail. That I have a problem with because it seems to me, if I were the magistrate, I'm getting half the story.
How?
I'm not getting the full story.
How? Please, somebody explain to me.
It might be one thing if what was testified to had been, well, these 10, that after that call on the 8th, there were other messages that were sent. They were work related. And then the 10th occurs. I just made that up on the fly. It doesn't seem that hard, but hey, that's not what was said. And I'll be honest with you, I find it a problem when the court isn't given all of the information for the court to make a proper determination of probable cause. I really have a problem with that. Because
Um, I, I'm going to keep going.
Quite frankly, I think that the defendant's due process rights, as well as the right of the people to be able to proceed with a validly sworn out complaint, are at jeopardy.
Does it impact the court to be mindful that the investigation was then and continues to be ongoing, and that there was always the plan and expectation of getting phones and phone records and further interviews?
That, does it make me feel, no, it doesn't make me feel any better. And the reason it doesn't is because if you think you needed that, then you needed to wait. Okay? But my problem isn't what's going to be gotten later. My problem is disclosing to the court what you have now. So that I realize whenever these complaints are sworn out, and quite frankly, whenever the court may be dealing with a moving case or a case that is, there's always this continuing investigation.
Sure.
So things can change. But, so the parties come in, and what do the parties do? They give the court what they have at the moment they got it.
Am I the only person that is absolutely fascinated and wants to know what his shirt looks like? Judge Simpson, can you please remove your robe? We want to see your phenomenally colored shirt. Sorry, I got distracted. Yeah, I think that's part of it. I don't know. Oh, Felicia, I think what the issue is he's stating that they wouldn't have given a warrant. The court wouldn't have given a warrant if this was presented differently.
All of that could change. That's unclear. So if you're asking, does that make me feel better? No, it doesn't.
As always, I appreciate the court's hearing. I am happy to answer further questions, but my position remains that even if you excise out the statements that defendant takes issue with, calls false, calls inaccurate, what you're left with still is more than enough for probable cause.
See, and that's the question I just
If you
had.
take the recitation.
But I don't mean to interrupt you, but it's not only taking out certain things. I would then have to add certain things.
You're worried about the omission.
Yeah, I'm very worried about the omission. I'm worried about the omission because those things at the very beginning that Ms. Sharp says create that context to the whole thing. I mean, the whole thing is sort of painted by that. And I think, quite honestly, that's why Detective Walker led with that at the swear-to. She's painting this picture. And it's all, I tried to look at it as objectively as I could, looking at the swear-to. It's all one-sided when you look at the other part. I think courts are entitled to more than that. You give us everything, let us make the call. That's what we give. But I don't think, well, what worries me, I won't say it indefinitely. What worries me is the magistrate did not get that opportunity. That's
Would
what,
it have mattered?
and if the magistrate didn't get that opportunity, that means what the people got may not have been validly sworn out complaint in terms of public cause properly being addressed. And if the defendant's due process rights, that's my problem, or my concern.
So what I'm getting is this wouldn't have changed anything, but he is trying to protect due process regardless of whether it had any bearing on whether the warrant would have been written. Am I finally on track? I feel like I'm finally there. Because I was trying to figure out why this mattered, and why the reason it matters to him is not the same reason that it would matter to me. Evidentiary wise, like as far as the evidence goes, he is concerned about due process. Got it. That makes more sense.
And I don't know how, which is why I asked Ms. Michaels about specific cases regarding omission. Because it's really easy if there is information that's in, and when you look at how most of the courts address it, if something comes in and it's false or it's reckless disregard for the truth, and then the court gets to the end and the court just has to ignore that and then say, oh, is there still enough for probable cause? Quite frankly, that can be a very easy analysis. I don't know well, I'll figure it out, but the analysis where something's missing.
And I don't disagree with that. I appreciated the court's questioning along those lines. I also am unfamiliar with case law that addresses that concept. My gut reaction has been all along to say that is because those are issues that are addressed at the sort of test the evidence stages, like a prelim, a bind over, trial, things like that. That's nothing more than a gut reaction. You don't ever want to endorse hiding the ball. You know, that's not who we are. That's not what the system is. That's not what the system should be. That's not what we stand for. Clearly the court is taken with, and again, I appreciate your candor, taken with an omission to put an employer-employee relationship on the record at the swear to. I can't fix that in the moment. I continue to believe the remedy is a preliminary exam. The court obviously may disagree, and if we hold a Franks hearing on that, then we hold a Franks hearing on that. I continue to be of the position that once that relationship is over, there is more than sufficient behavior that was sworn to that satisfies probable cause for the stalking, which then satisfies an element of the home invasion third. I believe that's for sure what Frank stands for, Williams, Franklin, all of that progeny of case law, whereby if the courts are willing to still say there's more than enough probable cause here, even if I excise out legit untruthful statements, which don't seem to in any way have been shown here, not from my perspective. And if there still remains probable cause, then the warrant is valid and there is no need for a Franks hearing. Then it stands to reason to me that if the worst that we can say exists on that record is a void of a fact pertaining to their employer-employee relationship, that if there still remains adequate probable cause on that record, that arrest warrant should still stand and there shouldn't be a reason for a Franks hearing. And I think that's probably all I have to say on that, Judge. If the board has any further questions, please.
Thank you.
Thank you, Judge. I appreciate it.
Yes, thank you.
All right. Let's see what she's got to tell us.
The first thing I'd like to address is the position the government is taking that there are enough stalking acts on December 10th after the end of the employer-employee relationship. Count 1, home invasion in the third degree, states that it is breaking and entering with the intent to commit a misdemeanor, and in this situation with the intent to stalk. So in order for home invasion in the third degree to have survive a probable cause analysis, relying on the acts post employee-employee relationship isn't good enough. They have to show that he went into her apartment with the intent to stalk her, which means there had to have been predicate acts of stalking prior to entering the apartment. If they are now saying that the only acts that we are relying on are the acts post leaving the apartment, the home invasion fails. And it should fail, because there was no stalking prior to December 10th or after is our position. That's one point I'd like to make. Second point I'd like to make, in People v. Eichler, in paragraph 6.
Counsel, can I just ask one question?
Yes.
In regard to the stalking, you may be very well be right. I don't think it's the time for the court to make the decision as to prior. But after entering, leaving, and then texting, those could be non-contiguous acts that could constitute stalking.
Too soon to answer that, honestly. I haven't been, my mind is.
That means yes.
No, not necessarily.
No, go ahead.
No, because
No,
stalking,
you're not. I understand.
Okay,
why you
stalking
don't
is the-
answer that, but those could potentially formulate a stalking charge. I might agree with you that the stalking, as it's framed in the complaint, isn't the predicate for the home invasion. I get that. But that illegal entry or potential alleged illegal entry and then text message could do that.
assuming it can show intent to harass and all these other elements that I would have to analyze, which is why I'm saying I'm not going to answer that until I actually analyze the facts.
That's okay, I got my answer. Go ahead, you can keep
But it's important though as to the felony. I mean, a felony is much more serious than a misdemeanor. So if the stalking fails as to going there with the intent to stalk, breaking and entering with the intent to stalk, that would have to have been a second or third act. You can't go and do something.
I'm not saying I'm disagreeing, with you.
Okay.
I'm just saying
Thank you.
that you made a statement
Understood.
that I might disagree with, but go ahead.
The government also pointed out that there, in the fact pattern that she just relayed to you about Mr. Moore walking towards the complainant while he was holding the butter knives. I'd like to point out that the prosecution or the charging agency, they're the ones who get to choose. They didn't charge him with assault or aggravated assault or any assault. They looked at the facts and didn't even ask for that. So to describe him as dangerous and assaultive, they didn't even see that as assaultive on that day. I just want to make that point.
It was a butter knife.
Finally, the prosecutor also stated that there was further conversations with the complainant to flush out more of the history. That conversation occurred prior to the swears. The in-depth conversation with the complainant was documented in the police reports and is on body cam, audio and video. And at no time does she describe a history of domestic violence or a history of stalking. And one more thing is, I was getting to Eichler, paragraph 6, the government tried to say that Eichler can only be applied to cases where it's a probation or relationship, that it's limited on its facts and should be seen as limited in its holding. Eichler actually states that the language from Eichler is this, that under Spalding, which is a case that they're citing, a reasonable individual is a reasonable person similarly situated to the victim, which necessarily means that we must consider Meyer's chosen occupation, training, and job-related responsibilities as part of our consideration of the circumstances or situation. It doesn't say we must consider one is a probation agent and one is a probationer. It specifically generalizes to the relationship between the parties, the employer-employee, occupation responsibilities. I just want to make sure Your Honor recognizes that Eichler is broader than what they are trying to make it be. Finally, with regards to the omission of the information of the employee-employer relationship, putting something on the record matters. That's why we have a record, that's why we rely on a record, that's why we make a record. If the employee-employee relationship isn't on the record, we cannot assume that she had any knowledge of it. Finally, if there was notice at all that, well, he's the head coach at Michigan, who knows that the complainant was his executive assistant? I put out there that that is certainly not anything that someone would take for judicial notice. I suspect that nobody knew that relationship until this incident happened.
I don't know that that's necessarily true because, and this is a special circumstance, there is a strong possibility that law enforcement was around this staff and may have known who his executive assistant is. So I don't know that that argument holds a ton of weight because of who he is, because it is the University of Michigan, and because it is law enforcement that would have provided security detail to him, especially with any crazy games with rival teams. So I don't know about all that.
Let me just co-counsel briefly.
Let's zippity-doo-dah for a moment here.
One next point to make is the prosecutor presenting to Your Honor that it is a known fact that Sherrone Moore is the head coach at Michigan. That known fact would be from the media, from the news, from various other places, and it's improper for a judge to rely on that kind of information and to swear to.
Let me just ask one other question. Let's say, hypothetically, we go through the entire thing, we have the evidentiary hearing. What do you believe the proper remedy is?
I think the proper remedy is a couple-step process. I think first, after the hearing and the evidence is presented, and Your Honor makes a determination of what was not true or recklessly presented because it's unsupported, and that is taken out, and then the omission is put back in, I believe it would be on Your Honor to then evaluate based on controlling Michigan law to determine if there's enough probable cause to support this not only the warrant, but the swear to. Not only the swear to for the warrant, but the complaint itself. The complaint has to be accepted by the court. The prosecution doesn't just, there is a process for Your Honor to review a complaint and accept it. So I believe a dismissal of the complaint would be appropriate remedy. I think a secondary remedy would be to suppress any and all evidence obtained after the arrest.
I guess maybe I'll put it more directly. Let's say you were to win on everything.
Yes.
There would be nothing that would prevent the people from seeking reauthorization.
That is correct, and it is my belief, based on my review of the materials, my investigation of this incident, that they wouldn't have probable cause to make these charges. I don't believe they have probable cause to make these charges.
Regardless, you just don't think that there is.
I believe when presented fully and fairly to a magistrate, I believe there is not probable cause to support these charges.
Oh.
And I believe there's less probable cause now than there was when the incident happened.
I don't know what that means.
I believe that the evidence that has
strong.
now been collected will show that there was not stalking.
Right, but I,
That's what I'm saying. is
right
that-
now, I can't, I'm not dealing with any of that.
Right.
Because you're, for the purposes of this motion.
Right, you're asking me, I believe the question was, let's say I win and everything's dismissed, they can go and just refile. That was the question, correct?
Yeah, I mean, there would be nothing other than the fact that there might have to be enough evidence to do so, to prevent them from doing it, right?
It's my belief there won't be enough evidence to do so. Thank you.
Thank you.
Interesting.
All right. Thank you, Council, both of you, for your argument and the manner in which you answered the court's question, and the court does appreciate it. I'm going to take a break. I will come back with my decision. I would, why don't we look at it this way? Just give it time to come back. It may not take me that long to formulate everything, but come back on the record about 4:15. All right?
I have no idea.
They know you get them there to court state officers.
All rise.
That man has a deep voice. That man's got a Judge Mrazek voice. That's what he's got. All rise. Did we just skippity doo-dah through all of it? Did they take an actual break? Hang on. I'm trying to get us. I want to see Judge Simpson's shirt. Oh, he's back. Not there. Okay, so it sounds like to me his issue is due process. So y'all got really quiet in the chat. Did I lose y'all? Let us see. We happen to know that he wants an evidentiary hearing after that's what his ruling ends up being. But let's listen to the lovely Judge Simpson.
Maybe see. Back on the
Gotcha.
record in the case of the people who are Sherrone Moore.
I usually do both, Kristen, for this exact
Counsel
reason.
is present as well as the defendant. And I, first of all, again, want to thank counsel for their well thought out arguments. And most of all for answering the court's questions, which since the filing of the motion for Frank's hearing, watched the arrest warrant have been heard of this course. This extended thought process. The important thing to request for an evidentiary hearing for some is first thing to realize is that in Frank's and the Michigan Supreme Court has made it very clear. Frank's, the requirement of an evidentiary hearing and the like based upon Frank's is the floor and not the ceiling. Michigan, I think it's the people that acknowledge, allows greater leeway and discretion for courts to hold evidentiary hearings regarding issues involving search warrant, arrest warrant, or warrants, where it is in some way demonstrated that there is either evidence which is intentionally or unintentionally, in certain respects, misleading or false, or where there is almost a reckless indifference for the truth. This case brings up sort of a different issue, but brings up the issue of intermission. What is clear from this court's perspective is that an omission in certain contexts can be more damaging, more problematic, more troublesome than what might be an intentional misrepresentation. In either way, or in any event, this court is of the belief that at every proceeding, every representation made to a court should be a full and complete representation to the court, so that all the parties can receive their due process. That includes the people, that includes the defendant, and anybody else coming before the court. The defendant wishes this court to have an evidentiary hearing regarding the issues. Fundamentally, it's focused around certain portions of the omissions, sort of the context particularly, as I gather from the defendant's argument, and what has been a concern of the court is the context of the relationship. People, on the other hand, don't believe that the court should be holding evidentiary hearing and that it would be an abuse of this court's discretion, which it has discretion, but it would be an abuse of that discretion to hold an evidentiary hearing. An abuse of discretion, what very clear from the case law, only occurs where the result of the court's decision or use of its discretion is outside of the range of reasonable outcomes. I don't believe that granting an evidentiary hearing in this case would be outside the realm of reasonable outcomes at all. And just by way of context, in looking at the swear-to by Officer Moore, what's clear, and also from the court's questioning, I think the parties realized where the court was going and should have. The initial part of that swear-to is not set out by the representations of the alleged complainant in this case. It's all set out by her attorney, Ms. Sharp. Virtually every statement is a rendition of what Ms. Sharp said to the police. It isn't until a little bit later into that swear-to that you get into particular statements that are made by the complainant in this case. When one looks at the Eichler case, one of the things to realize where the defense is heading is that the context, and I read it as broadly as a defense, that context to stalking charge, context of that relationship is critical to assessment of that relationship and whether or not there's this harassing behavior or stalking going on. As I can only imagine, this court doesn't know what an executive assistant to a phone call approach does. I don't know if phone calls or messages might be exchanged all times of the night. I don't know any of that. I can only presume that if they are the executive to effectively a CEO, the range of their responsibilities, duties, communications is vast. But again, I don't necessarily know that, but it's something certainly that the court should have been informed of during the swear-to. It's gone without any rebuttal that the phone calls that were alleged or alleged to have occurred during work hours, occurred during those times at which, as most might think, communications would occur. That the written messages, in terms of text, were admittedly employment related.
I hate you.
Representative of the court. I don't know why that wasn't given to the magistrate.
My boss better never text me, I hate you. My blood is on your hands. Sir, I love you and everything, but what in the wide world of sports are you talking about? I hate you. My blood is on your employment. Okay,
I think that
got it.
the evidentiary hearing would be necessary because there's no mention of the employment, that context given to the relationship. The context during the swear to is a one-sided rendition of things by someone else. It isn't, it by no means would constitute a full picture. More important, and it may go to the defendant's argument, although they didn't place it this way. I asked what might be particularly false in that statement. That's a tough question to answer. I appreciate the response that I got. But really, I think that the falsity really comes in the way that it was sworn at. It at worst is false and an outright lie. Or at best, it is misleading. And particularly when it talks about the 10 to 12 phone calls and text messages, there's not one mention of the fact that those to which they could determine were work related. There's not a mention of it. That is a huge, in this court's perspective, that's a huge omission. Because immediately afterwards, again, there's like a statement from the complainant about these 12 calls, making them seem as though they are somehow related to some type of harassing behavior because there's nothing on the other side to say what it may be. And then the immediate statement afterwards is a text message that came after the incident or later on the 10th, after the issue regarding the complainant's home. Frankly, I think that was intentional. I think it was intentional to place a context without saying it. Give the court a context. If you look at the very beginning, that he's this monster, he's this person that's been doing all of these things, been harassing her for months. You lead that down into all of a sudden this day comes along or the 8th December comes along. There are these 10 to 12 phone calls, which one might presume would be a continuation of the harassment, but we know are not any type of harassment.
Do we know that?
And then the December 10th. I don't
know anything.
I don't believe a lot of times in coincidence. I don't believe that things happen all the time by accident. I agree. I think that was an intentional misdirection to the court in terms of what this should look like.
Well, you don't want to be Miss Sharp, huh?
End up any place different than where the magistrate was. But the magistrate was owed the benefit of having all of that information prior to making that decision. It is in this court's mind a glaring omission to leave out or frame this relationship only in one way. That doesn't mean that it doesn't intertwine itself to a personal or professional. It doesn't mean a lot of things, but this was not solely this personal relationship. And the magistrate should have been able to look at that and determine what it would be. That you can tell right on the surface. I would suspect as you dig deeper, there would be other issues that aren't painted in their full context in terms of what happened. So for those reasons, the court, in exercising its discretion, is going to grant the motion for an evidentiary hearing in this case to be held. And counsel, I'm going to have a couple of questions for you. One is in regard to availability, and I would indicate to the parties that I would like to hold the PCC date if possible. So I'm looking at getting to this in quick fashion. The other issue I would have, or question that I would have in setting a date, is what witnesses you would anticipate calling, and I'll start with the defense.
So Melissa, what Judge Simpson is saying is that the magistrate that granted the warrant initially did not have all of the information because it was omitted from the paperwork that Sherrone Moore and Ms. Shiver had an employer-employee relationship. And because that was not included in that request for the warrant, the magistrate did not have all of the information to be able to make an educated decision on the warrant itself. So I get that part. He talked about due process before. I get that. Here is where I am. I know that Sherrone Moore's attorney, Ms. Michaels, has said once the evidence has been presented, she does not believe there will be any way that they can continue on any sort of prosecution. And I find that hard to believe. It's just my opinion. Yeah, Felicia, he wants all the receipts. He is like, get your brawny out, ladies and gentlemen, because we're going to spill some tea. And Sharissa, thank you for coming over and watching with us. I think that you're a little, free Kelsey Fitzsimmons. Thank you for covering this. Boyfriend, a huge Michigan fan, and this is one case can get home to watch. You are welcome. So that's where I think we are on this, Melissa. And so that's why he was declaring an evidentiary.
You may.
All right, we're going to zippity-doo-dah a little here while they can converse.
So the question was, what witnesses will I be calling? So it would be the government's burden of going forward to show that this was done properly.
It's your
So I guess
motion.
Maybe I can respond after they tell me who they would be calling. I don't know that I would be calling anybody once they put their case in.
Ma'am, this is your motion.
Really doesn't matter to me who goes first. I'm going to get to where I'm going to get to. Do you have what witnesses you anticipate calling? Understanding, and both parties just need to understand. I think I made it clear as to where my reservations and concerns are. And you folks are going to know those witnesses that would be able to clear it up the best for the court. So,
I mean, off the top of my head, Your Honor, I think the court, I would imagine, would want to need to hear from Detective Welker, from, I would imagine, the victim, and from Ms. Sharp. Whether I should present to the court anybody other than those three is something I would, I guess, ask for a little bit of time to think about. Those seem the obvious ones, Your Honor.
understand.
And if the court, I mean, I get it's my burden, my presentation, but I am mindful of the court's thought process, continue to be appreciative of the court's candor. If there are witnesses that the court would like to hear from, I will consider it my obligation to bring those to you.
Well, let me answer this. Were there officers that were part of the interrogation process or the questioning of the victim in this case
There were a couple, yes.
that were, so, and the only reason I say those is because Detective Walker presumably would have received that information from them, or at least that's a possibility.
Some of it, yes,
Okay,
yes.
so I think the officers that may have interviewed the victim.
There's at
Would-
least two more that I can think of that off the top of my head.
I have one moment.
Sure.
Conversing again.
I would agree that Detective Welker will be a necessary witness, and then I don't have the name offhand, but the officer who had a body camera on the scene would like to be a witness or potentially for purposes of impeachment if necessary.
But that officer, and maybe that's who I'm kind of referring to,
Yeah.
because that officer was the one that, I can't remember, I think somebody referred to it in something. That,
Bar Lawarca, who was the original respondent
Right.
officer.
that's
So that I would think would be for sure. There were a multitude
This
of other
woman right
officers
here looks
that
so
came in,
familiar to me, and I
from
don't
that
know
apartment.
why.
All of them had body worn camera. Some asked additional questions, some asked mostly repeated questions. There was one officer who did a follow-up phone interview, whose name is escaping me right now, Peterson, and that is a recorded follow-up phone call, Patterson, with the victim. So those are two for sure. If you're looking to hear from and see body cam.
I'm going to zippity doo dah here
interaction.
because
Camera.
we know none of this happens.
the court would have to see body worn camera. As long as there's an admission as to its foundation, I don't know that you're going to need the officer there,
Mhm.
per se. I mean,
Yes, we can talk about that, that's probably, we could probably stipulate to the foundation
I
of
was just going to
those.
say, can't
body
you just
cameras.
stipulate?
There was the initial officer who talked to the complainant, and then later on, maybe a half hour later, there was a follow-up interview on site. I'm not sure if it was the same officer or not, but we'll make sure we figure out which body cams are relevant.
Yeah.
Okay.
Officer that is.
I'm zippity doo dah because this is a lot of logistics, and I happen to know it is not going to matter.
okay, good. And this is going to be an all-day variance. So. That's significant. However, I would have, and can cancel dockets. I would have March 2nd and March 9th available. And if I cancel that,
To begin March 9th, it might be resolved in probably just second, they may all wind up being good. from
All right.
this perspective.
So
Thank you.
this is them
I
figuring the scheduling part out here. I'm going to get us in a position to see the next the next hearing that took place, which was last week. And Sharissa, please, I don't know if your boyfriend is interested or not, but on my channel, I have every intention of also covering Stefan Diggs, Antonio Brown, and the case I am sitting and waiting with bated breath on, John Gruden suing the NFL. I am absolutely, positively going to cover all of those cases on my channel. So if he is a football person, those are all football related. He's going to want to come tune in over here with you so that he can catch up on all of it. But right now, I'm going to try to get us caught up on what happened on March 2nd, which was last week, last Monday. Great, Sharissa. I am happy to know that you'll be here for it. I have no idea what I'm going to cover on Wednesday, but it might be one of those cases since we're coming up on things, on stuff. Let me get our closed caption on. All righty. Here we go. This is what happened when he agreed to plea. Let me zippity-doo-dah until the judge comes in.
The 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J. Cedric Simpson presiding. You may be seated.
Look at that. Look at that shirt, y'all. I want to see this man's wardrobe. We had to look at dumb Judge Lisa Lott's awful wardrobe. She didn't even cover it up with a robe, remember? But Judge Simpson here, bringing it. I am loving this. I hope he raises his hands enough that I can see the cuffs.
Court does call the case of People State of Michigan versus Sherrone Moore.
Good afternoon, Your Honor. Katie Rismersky for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sherrone Moore, who's present in court. Please state your name.
Sherrone Moore. Thank you.
Christine K. Jacobs on behalf of Sherrone Moore.
All right, thank you. All right. So date and time set for our friends here. Thanks. And even before you go on, I just want to express the court's appreciation for the hard work of counsel going through. I know it may have been a delay for the people that were waiting to see something, but your efforts were greatly appreciated. Ms. Richards.
Your Honor, thank you, and I appreciate the opportunity to address the court. First, allow me to apologize to the court and counsel. I was needed unexpectedly elsewhere in another county on a special prosecutor case this morning that went.
Miss Frizzle didn't get any better, but I love that jacket too. That's a really good color on me. Ma'am, I want your jackets, but you need to find a comb or something. You look like you've done your hair with an egg beater.
Perhaps a little bit longer than expected, and then as life unfolds, I was rear-ended in a gas station parking lot. Everybody is fine, but I really appreciate everyone's patience.
No.
It was not intentional. Thank you.
No.
Judge, I appreciate the opportunity to address the court about what has transpired and where we have arrived. This case, as is true with many cases, Your Honor, is alive and sort of moving and breathing. Investigation has been ongoing. An exchange of information has also been ongoing. As a result of all of that, where we have arrived,
I'm going to back it up, Kelly.
I really was first, allow me to apologize to the court and counsel. I was needed unexpectedly elsewhere in another county on a special prosecutor case this morning that went perhaps a little bit longer than expected. And then as life unfolds, I was rear-ended in a gas station parking lot. Everybody is fine, but I really appreciate everyone's patience, and it was not intentional.
She was having a day.
Judge, I appreciate the opportunity to address the court about what has transpired and where we have arrived. This case, as is true with many cases, Your Honor, is alive and sort of moving and breathing. Investigation has been ongoing. An exchange of information has also been ongoing. As a result of all of that, where we have arrived, based on what we now know, is that we feel the most appropriate charges to address the defendant's behavior on December 10th of 2025 are two additional counts 4 and 5. We would be seeking to add a count of what we call malicious use of a telecommunications device in the context of a domestic relationship, and then an additional count of trespass. Those are, as Your Honor is aware, misdemeanor matters. Your Honor, we have arrived at that as indicated based on a thorough review of the additional evolved evidence and investigation, as well as after consultation with, pursuant to our allegation, the Crime Victim Rights Act, consultation with the victim, largely through her representatives in this matter. Your Honor, one comment I would like to make specifically about the additional count of malicious use of a telecommunications device in the context of a domestic relationship. As this court is aware, but I would like to be clear for the record because of, I know, docket and calendaring purposes. Your Honor, we did not at the time of issuing initial charges in this matter, nor do we believe now after additional evidence has been presented to us, do not believe that there is sufficient evidence to prove a count of domestic violence in this matter, not historically and not what happened on December 10th. So we are obligated, as this court is well aware, legally and ethically and morally to not charge that which we do not think we can prove. What we do believe the evidence supports is criminal misbehavior in the context of an intimate partner relationship, and that is why that tag on is on the malicious use charge. Your Honor, it is my understanding that pursuant to adding those counts, that there will be a plea as a result of that, but I leave that.
So it was still icky behavior. It was still icky.
Do you want to say something?
Yes, thank you so much. I'd like the record to be clear that the negotiated disposition involves a dismissal of the 3 charges that had been charged. That was not mentioned in the recitation by the prosecutor's office.
That is absolutely correct. The end result of where we land by adding on the counts is that my best understanding is that the defendant will enter a plea to those additional counts, and in exchange for that, we will absolutely dismiss the originally charged 3 counts. Thank you.
And that would be an entering of a no contest plea to count 4 and count 5 with the dismissal of count 1, 2, and 3. Thank you.
The court does have before it a favoring form that indicates that the defendant will be pleading no contest to the charge of malicious use of a telecommunications device, domestic relationship tag. That is a misdemeanor punishable by up to 6 months incarceration. He will also be pleading no contest to the charge of trespass, which is a 30-day misdemeanor. Upon a successful no contest plea to those charges, counts 1, 2, and 3 will be dismissed. That is the court's full understanding of the agreement. There is, however, one other thing that should be mentioned, and that is with reference to sentencing. The court is going to be given full authority, if the court deems it necessary after a review, to sentence under a deferred program. That is the court's understanding.
That is also correct, Your Honor.
That's correct.
Very good. Mr. Moore, counsel, if you could approach the podium, please.
All right, Sherrone, baby. Time to speech.
If I may have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Sherrone Moore.
Mr. Moore, it is this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. The first charge is the added count 4 of malicious use of a telecommunications device involving a domestic relationship. That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
And also the added count 5 of trespass. That is a misdemeanor punishable by up to 30 days in jail and or a fine not to exceed $250. You understand that, sir?
Yes, sir.
You understand where no contest plea is?
Yes, sir.
All right. 2 things about a no contest plea I have to make sure that you understand. First thing is that it first of all means that you're not further desirous of wanting to contest these 2 charges. You understand that, sir?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Basis for the no contest plea, counsel.
The basis for the no contest plea is civil liability
potential civil liability.
Yes, civil litigation.
Got it.
Civil litigation.
Moore to the charge of malicious use of telecommunications device. How do you plead?
No contest.
To the charge of trespass. How do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
I don't think he has executed any vice rights form. I think he did, actually. I don't think.
That's, I think, why he took the
I believe
plea.
he did, and Raymond,
And Raymond, do you recall that, sir?
Not on the top of my head, sir.
Pardon?
Did you,
Not off the top of my head.
I have one that I printed up just so we can continue. I did go over the advice of rights form with my client yesterday. So him signing it now is acknowledging that he did review it yesterday.
All right, is that correct, sir?
Yes, sir.
I'll let you say that. Did you have any questions regarding any of the rights that are contained on that?
No, sir.
You understand that by pleading no contest, you're waiving or giving up the rights that are contained on that.
Yes, sir.
Particularly the rights that are contained under paragraph 5. You'll see a copy on the podium, which are your trial rights. You understand that you're giving up that?
Yes, sir.
You understand you're giving up your right to appeal?
Yes, sir.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed thoroughly Pittsfield Township Department of Public Safety report for their case number 25-25629. Counsel, any objection to the court having reviewed that report?
No objection. No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these two offenses. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit any misconduct as defined under the Michigan court rules, you would first of all not be entitled to withdraw your plea. You understand that?
Yes, sir.
And also, the court would not be bound by any sentence evaluation or recommendation. Do you understand that?
Yes, sir.
Is counsel aware of any promises, threats, or other inducements which have led to this plea?
There are none, Your Honor.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant?
Court has.
Yes, Your Honor.
The court will accept the defendant's no contest plea to counts 4 and 5. Counts 1, 2, and 3 are hereby ordered dismissed. The pre-sentence investigation and report is ordered. Sentencing in this matter will be, will April 13th work for parties? I have April 13th or April 20th at 11 a.m.
April 13th works for the defense.
Much better for the people.
Well, hold on one second.
I had it on the 14th, so I wonder if they changed it.
Hang on a second. April 8th, will that work?
I'm not available. I'll be in trial in Oakland County.
And the sentencing will go smooth. No. April 22nd in the afternoon.
That's good for the defense.
Will that work for the people?
Judge, I personally will likely be unavailable in a trial, but it sounds like my office could make certain that it's covered. If that's the
We've
purpose.
been here from the beginning. We might as well try to make it work for you too. Give me a special.
Tuesday, April 14th
Will the fourth,
in the afternoon.
April 14th in the afternoon work?
That should work.
I'm checking.
I thought I had the 14th.
April 14th works for the defense.
April 14th, 2026 at
2 p.m.
2 p.m. Before me.
2 p.m. Eastern time.
Anything else about it?
Nothing from the people. Oh, I'm sorry.
Yes, as to bond, we are asking that the bond condition of a GPS tether be removed as a condition of bond for the following reasons. The tether was placed when it was the understanding that the charges my client was facing was a felony and a stalking charge. Now that those charges are dismissed and the narrative of my client being having a history of violence and stalking has now been proven to be false, it's our position that the tether is no longer necessary. There is still in effect a no contact order by my client to the complainant or by any third party to the complainant. He will absolutely abide by that no contact provision, and he has no intent to, by himself or anybody else, to contact the complainant.
All right. Any response from you?
Your Honor, I would say that I am comfortable leaving the matter of the tether in the sound discretion of the court. I will reiterate that our victim's most fervent desire is that the no contact, either direct or through third party order, remain in effect, and that is her highest priority and therefore ours.
All right. What I'm going to do, and that provision regarding the no contact either by the defendant or a third party does remain in effect. I'm going to, at this time, however, deny the request for the removal of GPS tether until such time as the defendant has been interviewed by probation, and I will make a decision on that based on a recommendation from probation. All right.
Thank you for that consideration.
Thank you. Anything additional?
I
No, Your
didn't see that
Nothing
coming.
from people. Thank you.
Fantastic. Again, thank you both for your hard work on this and for getting it done. Thank you.
Thank you so much.
Court stands adjourned. All rise.
Okay, Kelly, you said his wife is all over that no contact. I bet she is. Let's back her up, because you said she's smiling in the back. I'm thinking you're talking about this lovely lady here. Is that who we're referring to? Is that the old whiff right there? Yes, it was a good deal for him. Got a good plea, felonies dropped, the two misdemeanors were what he pleaded no contest to. He has a good chance to overcome this and at some point return to coaching. I don't know about that. And the reason I say I have concerns about the coaching is because this was not the only shenanigans that Mr. Sherrone Moore was up to during his time at the University of Michigan. And so I think in light of this and all of that, it's going to be a very, very steep hill for him. All right, let's watch the whiff, shall we?
And that is her highest priority and therefore ours.
All right. What I'm going to do, and that provision regarding the no contact either by the defendant or third party does remain in effect. I'm going to, at this time, however, deny the request for the removal of GPS tether until such time as the defendant has been interviewed by probation, and I will make a decision on that based on a recommendation from probation.
Oh, that's funny.
All right.
Thank you for that consideration.
Thank you. Anything additional?
No, Your Honor.
Nothing from people. Thank you.
Fantastic. Again, thank you both for your hard work on this and for getting it done. Thank you.
Thank you so much.
Court stands adjourned. All rise.
Dude, you got so lucky. So lucky. Yeah, I don't think the PR will go well for coaching. He shouldn't be allowed in that position again. Yeah, there were so many things he did some shenanigans with the whole sign stealing business. He lied to the university about the sign stealing stuff. There's a lot. This is a very, very dishonest man. And I say that as a huge Michigan fan. I wanted to see him succeed. I was so happy when he was promoted to the head coaching position, and then, stuff happened then. So yeah, I think coaching might be a little difficult because oh, Melissa, you don't know about the sign stealing, huh? Oh yeah. My best advice, there is an Untold on Netflix that is about the entire sign stealing episode. Go watch it. It is quite an education. I will not do it justice to even have any sort of conversation. But there was an investigation done at the University of Michigan. And when that investigation began, Sherrone Moore was avoiding being questioned. He was dishonest about the information he gave when investigators questioned him. And so, you know, stuff. So I don't find him to be an honest individual. And Kristen, thank you so much for being with us this evening. I have no idea what I am going to cover on Wednesday. I need y'all's help. So I can check my docket. Let's see what we may have. I haven't done anything on Kelsey in a while. Are y'all feeling like we need to do a revisit on Kelsey Fitzsimmons? I know I believe, Kristen, it is Untold. It's a series, and you'll want to find the one about the Michigan sign stealing. So we have Raul Valley has a hearing coming up later this month. Kelsey Fitzsimmons' trial starts on the 23rd. So y'all can let me know. And then Barry Morphew was supposed to have a hearing today. I have not had a chance to look to see what happened or if that even happened, to be honest. And I have Brad Simpson on the calendar for the 19th. That's kind of what's going on based on my docket for this month. Kelsey, do we need to go back to Kelsey? Yeah, I feel like a lot happened there. So I will gather some information and we will, I know a lot of other channels have covered Kelsey Fitzsimmons, the recent motions and things like that, but I'll see what I can find out. Yeah, the alien I know broke into the house and that. So we'll try to cover some of that stuff. And I did see that Lauren Katie, you all may remember her. I have had her on my channel before. She and Maza Media, they have collectively now raised over $100,000 for Kelsey Fitzsimmons' defense. So I think that's fantastic. You all know I don't do the fundraising business. That's just not my gig. But I am absolutely excited and supportive of anyone else doing that kind of fundraising. And let's not forget, Tickety Talk, guys. Today is the 9th. Judge Bradbury in Tennessee. He's got to be panicking a little bit. You know, only a few more weeks. He's going to have an answer about our friend Zach Adams. Please tell me you're going to vacate his sentence. Please, Judge Bradbury. You get to be another judge I can love, please. So I will work on getting some things put together for Wine and Crime Wednesday to go over Kelsey Fitzsimmons and the alien, as Mr. Michael Bryant calls him. And there was something else I was going to remind you all. Oh, smash the like button, leave some DNA if you haven't already. Kelsey, I feel like there was something else. Raul, we'll try to get back to that later this month. And we will head on down the road. I know as soon as I end this live stream, I'm going to go, I remember what it was I was going to tell everybody, but I, for the life of me, cannot remember right now what it was. Courtney Clenny, don't y'all forget, She's going to be coming next month too. That trial starts on the 16th of April, and I am contemplating, y'all need to let me know in the chat whether we need to do an evening replay of that trial. We'll get behind for sure on that one. Just like if I were to do Corey Richens, I would be way behind right now as well. But of course, you can always get caught up on the Saturdays, I suppose. Y'all let me know if you think that would be a good one for us to replay in the evenings once old Courtney's case gets going, since we did a pretty good deep dive on that one. Outside of that, my camera just went nuts again. Outside of that, thank you so much, replay crew. Thank you to my mod, Kelly. I appreciate it. I appreciate everybody that came in the chat, even those that were just a peeping. Thanks for the peepers. You know who you are. Trying to not be a fan of Ms. D, but we know you are. It's okay. But it is now time for me to call an end to this evening with all of you. And if we have a verdict tomorrow, we will be back tomorrow night. It'll be later. Make sure you have notifications on so that you'll know when I'm going to go live if we do have a verdict tomorrow. Otherwise, we'll be back for Wine and Crime Wednesday, and we'll do a little Kelsey Fitzsimmons business. In the meantime, remember, it doesn't cost a penny to be kind. So find someone to do something nice for today if you haven't already. And as always,